Still in politics, the Cape Coast High Court has annulled the results of the 2020 parliamentary elections in the Assin North constituency. The court, presided over by Justice Kwesi Boakye, ordered for fresh elections to be conducted in that constituency. The state of the petitioner, or the case of the petitioner, is that the MP Joe Gyachi Kwesi, at the time of filing to contest the 2020 parliamentary elections, had not renounced his Canadian citizenship and thus held dual nationality. There's more in this report.
In the 55-page judgment in front of a packed court, the judge, Justice Kwesi Boakye, said the MP, Joe Gyachi Kwesi, violated constitutional provisions and other statutory provisions that guide Ghana's elections. Consequently, he cancelled the 2020 parliamentary elections that were conducted in the Assin North constituency and ordered for a fresh election to be conducted. By the court's order, Mr. Gyachi Kwesi should not hold himself out as the MP for the Assin North. Before the orders of the court, the judge took time to deal with the 4 issues that were set down for trial. On the issue of the capacity of the petitioner to maintain an action against the Assin North MP, the judge said the petitioner had the capacity and the petition was competent as well. The judge accordingly overruled the MP's challenge of the petitioner's capacity. The court explained that its jurisdiction could be invoked in an election petition when the EC conducts a parliamentary election and declares the result of the contest. Thus, he argued the court's jurisdiction was properly invoked. On the second issue on whether or not the EC erred in the discharge of its duties and allowed Mr. Joe Gyachi Kwesi to file his nominations, the judge also indicated the independence of the EC in the conduct of elections in Ghana was not in doubt, and the court won't interfere in the operations of the EC unless an illegality and an unconstitutionality are being perpetrated by the EC. The third issue on when Article 94(2)A kicks in, the judge said based on the certificate the MP submitted in his affidavit in response to the petition, he only ceased to be a Canadian citizen on November 26, 2020, and not any period before or at the time of filing to contest the elections. The court indicated that the evidence on the face of the certificate destroys the case of the Assin North MP. According to the judge, it would be a bad precedent and a cancerous tumor in Ghana's legal jurisprudence should the court allow that to happen. On the final issue on whether or not the election of the Assin North MP is null and void, the judge said the MP violated the constitutional provisions and other statutory provisions that guide Ghana's elections, and so the elections were null and void. A member of the NDC's legal team, Alex Sebefia, says it was a travesty of justice and the NDC would deal with the case to its logical conclusion. He adds, should there be a by-election, the NDC would still win the seat.
It says you must be a citizen of Ghana. If you are not a citizen of Ghana, you cannot hold certain positions. You cannot hold this position, president, you cannot be a chief of defense staff, etc., etc. And in 94(2), it says you cannot be an MP if you owe allegiance. There's a big difference between allegiance and citizenship.
Now, Richard Kojo has been gathering some reactions from the constituency and joins us with more. Kojo, what have you been picking up since the ruling?
Also, it looks as if that people are now digesting the ruling or the judgment of the Cape Coast High Court. In fact, some of them are angry. They feel that Mr. Joe Gyachi Kwesi is loved in the constituency and has that intent to do very well for the constituency. And so they didn't see the reason why that challenge even came in the first place. And then the elections had to be cancelled in the second place. But there are others too who feel that, well, if you are contesting an election, you need to gather all the materials, all the requirements necessary to enable you to contest that particular election. And so they hold the view that the High Court was right and the person that sent the matter was right, even though that person who petitioned the High Court comes from Assin Breku, the constituency capital. In fact, initially, they had issues with him. They didn't understand why he should do that to them from that constituency, or why he should deny the people of Assin Breku the right to, someone who comes from that place. And so they are divided, but each of them would have a point. They raise the point and defend the point that they have. And so they are waiting for the decision whether there will be an appeal by the NDC bench or they will allow the by-election to go on. And so this constituency is predominantly a farming constituency, and it also has a lot of settler communities that are also sprawled around that particular. And so if you look at the history of the elections that have taken place in that particular constituency, you had Kennedy Japan, who held the seat from 2000, 2004, and 2008. In 2012, the constituency was split into two, and so that is why you had Kennedy Japan going for the Assin Central seat, and then the north of it became the Assin North, where one Ambri of the NDC won the 2012 elections, and then in 2016, Abna Dua Mason of the NPP won, and then in 2020, Mr. George Achikwesin also won. And so this has been the history of this particular constituency, Daniel.
Okay. Now, Richard, you were telling me that the reactions are mixed from the people. Would you say that the division and the reaction is along partisan lines? Would you say that it's just simply NDC sympathizers and supporters saying that this challenge should not have been brought, and MPP people saying that, look, if you're going to be an MP, be prepared, or you're getting some neutrals? Right, Richard, can you hear me?
Well, so largely it's along partisan lines, but along the line you find some people who belong to the NPP sympathizing that, oh, okay, but they come from that community. They feel that Beku had been given an MP who comes from that particular area, and so that challenge shouldn't have taken place in the same period. But I mean, because they are party people, they see also some reasons in the decision their party took, or the petitioner also took, likely because this is a civil case between a petitioner who the MPP do not want to say that it comes from their fold, but this is purely someone who petitioned the court, but it inures to their benefit, and so they seem to reason along the same line with the petitioner, and so that is how the thing has been. But you remember that some time ago, the regional minister visited that constituency, and the chiefs from that particular traditional area indicated to the regional minister that they want a representation, and they want
Right, Richard Kojonyako there from the Central Region, giving us a Zoom report there. Unfortunately, we seem to have lost him on that, so we'll move to other stories. Let's now hear from the National Communications Officer of the NDC, Sammy Jemfi, speaking on this subject.
Rollins didn't need to show any certificate of renunciation before he can be said, or he could have been said to have renounced his allegiance. He said, this President Rollins is a member of the Ghana Armed Forces. He has sworn an oath of allegiance to Ghana, both as a soldier and also as president of this country at different, times. And apart from that, the nomination form he filed to contest as president on the ticket of the NDC in 1992 had a statutory declaration in which he had sworn before a commissioner of oath and declared solemnly that he didn't owe allegiance to any country other than Ghana. So by virtue of the fact that Rollins, as a soldier and as a former president, has sworn allegiance to Ghana, by virtue of the fact that President Rollins had submitted a statutory declaration to the EC at the time, swearing that he owes allegiance to no other country apart from Ghana. Justice Silfi in that case, Bilson versus Rollins, said, whether he has a certificate of renunciation or not is inconsequential. Okay. That alone constitutes evidence of constructive renunciation. Why is it that now we are being told by our courts that until a foreign country issues you a certificate of renunciation of your citizenship of that country, you still owe allegiance to them? When you are a citizen of Ghana, you have sworn allegiance to Ghana, you have submitted a statutory declaration in which you have sworn that you owe allegiance to only Ghana. We are saying that until that foreign country accepts your application of renunciation, you still owe allegiance to them. What kind of interpretation is that?
Professor Kweku,
what kind of interpretation in that?
What exactly can be done?
On JoyNews Desk, let's stay a bit further on this subject because Professor Kweku Asare also spoke on the show.
if you owe allegiance to a country other than Ghana, you cannot be an entity. But it is also about so many other things, because I have a list here of things that you cannot do if you cannot be an MP. You cannot, for instance, be a minister of state. You cannot be a deputy minister of state. You cannot be a cabinet member. You cannot be a speaker of parliament. You cannot be a member of the electoral commission. You cannot be a member of the Public Service Commission. You cannot be a member of the National Commission for Civic Education. You cannot be a member of Lands Commission. You cannot be a founding member of a political party. You cannot be an executive member of a political party.
That's a tall list.
Leader of a political party.
For the sake of time.
So the question then is, what really is citizenship? What does it mean to say you are a citizen of Ghana? You are a natural born citizen of Ghana, and you cannot be anything. Obviously, the scope of restrictions alone should alert us that we are misinterpreting Article 94(2)(a). My understanding of Article 94(2)(a) is that it applies only to naturalized Ghanaians or registered Ghanaians. This is the common sense approach that the Nigeria courts have used. The Nigeria courts insist that a natural-born Nigerian cannot be excluded from the political space.
So clearly, Article 94(2) should be looked at again.
Be repealed, and there's a bill to that effect that has been gazetted that we are pushing through. I was in Accra about, I just arrived.
And that's Professor Kweku Asare there. You're live on JoyNews Desk with me, Daniel Dazi. Up next is Business with Daryl Kyle.